This paper is the philosophy of law. The module is on IT frauds and Indian legislature. The objectives of this module are to understand the legal regime related to IT fraud and also to understand some of the moral and legal implications of this. The content writer is Garima Goswami, an independent research scholar in New Delhi. I'm Akash Singh Rathore from the Lewis University of Rome. Let's begin by understanding what is at stake, the problems that IT poses in law and moral philosophy. In 2010, the important continental philosopher Slavoj Žižek published a book called Living in the End Times. What he meant by the end times was that there are certain problems in global order that are beginning to spin out of control, and he suggested that, like the apocalyptic predictions of common to Christian styles of thinking, also available in other religions, but very poignant in the apocalypse of the Christian Bible, that these end times seem to be coming. Now, in the Christian Bible, the end was announced. The apocalypse came on 4 horses. This is a kind of symbol, the 4 horsemen of the apocalypse. And Žižek speaks of the 4 horses of the apocalypse that characterize the end times that we're living in today. We don't need to get into them one by one, but the first 3 related to the biogenetic revolution. In other words, that technology has advanced in such an extent, the ability of biologists to manipulate the genes and the introduction of technology into genetics and so on, that we really don't know what will be the consequences of all of this manipulation 10 years from now, 20 years from now. Will there be androids? Will there be enhancements, genetic enhancements, bionic enhancements in people and things like this? And we have no laws to cover it. We have no moral philosophy that has ever treated it, because these are new discoveries and the philosophers of the past were unaware of them. And we basically have no direction. So this is one of the horsemen of the apocalypse, the possibility of biogenetic revolutions more or less leading to the extinction of the human race as we know it. Another one are basic system imbalances. In other words, we have the customary belief that capitalism is increasing the wealth of masses and lifting masses out of poverty and so on. But the statistics show very plainly that there's globally a decline of the size of the middle class, especially if you remove China from the statistics, that income inequality is at its highest moment than it has been in any recent memory. So the amount of wealth and assets that the few rich control is greater than it has been almost since feudal times. The poor have very little assets and next to nothing. So this is called a system imbalance. This is the second horseman of the apocalypse that Žižek thinks might lead to the destruction of political society as we know it. The third relates to the environmental catastrophes that are coming. We all know about the environmental decay and degradation and so on. This can lead to the end of the earth as we know it. And finally, we come to the one that relates to the heart of this module, which is on the impossibility of properly regulating technology and the classical idea of intellectual copyright. So we know that when you produce something, when it's the fruit of your own physical labor, that object belongs to you. So if you work for a factory, obviously your labor belongs to the factory, so the object belongs to the factory. But if you're working at home or for yourself, the thing that you create belongs to you. Well, what about intellectual creations? What about ideas? Can we patent ideas? Can we patent the some phrase that I've come up with? And if we do, what sort of consequences are there in the spreading or the sharing of ideas? We think of ideas as being perhaps our own creation, but informed by culture, by society, by earlier ideas, and so on. So what happens with the attempt to regulate intellectual property, and IT technologies fall into this category as they're created by algorithms that were invented through people's intellectual effort and so on. How do we regulate this, and is it possible to regulate it in a way that is analogous to the way that we have regulated physical property? Zizek argues no, and in fact all of the problems of IT fraud, intellectual property cases of dispute, espionage amongst businesses trying to steal the ideas of other businesses, and source code theft. Source code is a digital thing. It's not necessarily a physical thing, and it's the product of the human mind. Server hacking. All of these problems related to IT fraud and the near impossibility of regulating the new internet technologies, Zizek sees as the fourth horseman of the apocalypse. In other words, the fourth reason why we are clearly living in times that may spell disaster for humans, for the planet, for the world, for the future of humankind. So IT fraud can be understood in this philosophical backdrop as being a fundamental moral and philosophical problem, even though we articulate it in purely technical or legal terms. Now, what are the other types of IT fraud that are common, and what is the legislation related to it? We all know about illegal camcording, which is called bootlegging, when somebody walks into a theater and has a video camera and starts filming the movie that's on the screen, so that bootlegged copy of the film can then be distributed, and people don't need to pay to go to the cinema. There's also data theft. There's the theft of information, which is a serious global problem. Software piracy by server hacking, data breaches. More old-fashioned, there's asset theft. In other words, the stealing of laptop computers, but the consequence of stealing computers, desktops or laptops, are that you then have access to data and can mine that information as well. And then there's cyber squatting, which we'll also discuss. Now, the problem of why IT fraud is so rampant, and keep in mind that India is regarded always in each of these issues that I mentioned, bootlegging, cyber squatting, data theft, is always in the top 10 of the world for frauds related to internet technologies. It's on the top 8 of the global watch list. It's notorious for piracy, bootlegging, and it's a major area of contention and dispute between the producers of this kind of information and the government of India, which is told that they must crack down on the enormous IT fraud amounting to billions and billions of US dollars that happens every day in India. Why does it happen? There are not sufficient laws. That's one reason. Interestingly, 23 states and union territories in India have special cells devoted specifically to treating of IT frauds. So even when there are sufficient laws and sufficient attention focused on it, the existing laws that are there are not helpful in actually deterring the frauds. Take, for example, bootlegging. It's not actually written in any law in India that it is illegal to take a camera into a theater hall and record a film. So there's simply no law against it. How it's prevented is by the distributors of films cooperating with movie theaters and basically bullying, we can say bullying because they're not enforcing a law, bullying people with these video recorders out of the cinema halls. Now, when there are laws, there's also a lack of effective implementation of the law. And this has many, this takes many forms. Take, for example, the somewhat humorous fact that it's been discovered that about 50% of the bootlegging that occurs in this country occurs with the cooperation of the members of the movie distribution industry. So corruption is a big problem, if you consider that corruption, and the lack of the authorities' implementation of the existing laws. India is a forerunner in movie piracy. Pirated movie CDs, movies are easily available on the internet. Though the Indian Copyright Act of 1957 contains provisions of copyright infringement, and as I had mentioned, there are special cells in 23 states and union territories, we still are in the top 5 in movie piracy in the world. Despite legal provisions and administrative resources, there's a lack of effective enforcement of that copyright law of 1957. What are the ways that we can approach the rampant fraudulent behavior? Obviously, one approach is that Bollywood movies can be subsidized, or that they can be put more quickly onto CDs. In the past, it would take 10 years for some popular film to become available for use at home. These days, the Bollywood industry is getting a little smarter about this, and if they can produce CDs immediately, this discourages the bootlegging and the distribution of unlawful copies of the film. Another way that this can be approached legally is that courts issue temporary injunctions. That is, they allow an authority like the CBI to shut down websites that are engaged in providing free access to copyrighted content. So there's a famous case of Pirate Bay being shut down. We'll discuss a little more later in the module what the implications of this action might be. But this is another measure that can be used to curb IT frauds of various kinds. Now, what is camcording? Camcording is the illegitimate recording of a film which is being screened in a legitimate venue. Between 2009 and 2011, there were 155 forensic matches for cases which were found to involve the Motion Picture Association members. That's what I had mentioned before. This is a case of corruption. So on the one hand, the population at large is being blamed for bootlegging and camcording, but on the other hand, we find out that actually members of the Motion Picture Association are involved in conducting this camcording themselves. Forensic matches mean that they were able to trace who recorded to the camera that was used. There's going to be a bill called the Cinematographic Bill that can help in curbing piracy through camcording. As I mentioned, there's currently no law against it, so theaters just have to cooperate with law enforcement officials to sort of bully people out of doing this activity. Now, moving on to some even more serious issues, international issues, are information theft and source code theft. The Indian Copyright Act has no protection. It was drafted in 1957 when none of these things were even conceived. And the amendments that have come lately, 2013, 2014, have still not sufficiently addressed the problem of source code theft, and patent protection still remains weak. Patent protection remains weak, not necessarily because the laws aren't there that protect patenting, but there is a certain requirement of registration, and it has been found empirically that in most of the cases that copyright has allegedly been infringed, there was a failure on the part of the author, the writer, the filmmaker to properly register the copyright. Now, trade secrets is a very interesting case involving both crime, the protection of data, and and the spreading of these secrets or data, popularizing them, or popularizing certain innovations that were developed in corporate research laboratories. Interestingly, India does not deal with trade secrets through criminal law. It deals with it through contract law. Now, contract law are relations between two parties, and if the relationship is violated, then one of the two parties can appeal to a third party. That third party is, of course, the state, the judge, a mediator, an arbiter, in order to attempt to force one of the people to perform the agreements of the contract. So this is the way that India currently deals with the trade secret. When somebody joins a corporation that deals with innovations in technology or ideas, it signs a contract with the employee that demands that the employee promises not to reveal those trade secrets. Well, this is not adequate, because what are the consequences of breaking a contract? Unless you move into the domain of criminal law, the consequences of violating a contract are usually just related to your salary or something else that doesn't really pose much of a threat. Let's say that I'm drawing a salary of 1 lakh a month from the company where I work. I have access to certain secrets of the trade. I've signed a contract that I will respect my responsibility as an employee to keep these secrets. If I can get 1 crore for this secret from another corporation, what does it matter to me if I fulfill my contract with my employer and lose my 1 lakh per month that I am drawing? Obviously, trade secrets need to be protected within the domain of criminal law and not simply within the domain of contract law. Another very serious and yet fascinating problem is cloud server hacking. This is fascinating from the point of view of the philosophy of law, and it's very serious from the point of view of international regulations of data protection and privacy. So when we come to the IT fraud that we refer to as cloud server hacking, something quite unique arises. What is cloud server hacking? Cloud server hacking is when the data that is stored in the cloud, which is to say data stored not in a particular hard drive of a particular computer located right there on your desk, but rather uploaded through the internet and then stored in multiple locations, both hard and soft, hard drive and stored electronically. This cloud of data then moves around the world. Different servers and different internet service providers are transferring this data one to the other around different regions of the world. Sometimes this data could appear in mostly North African servers. Sometimes it can appear in North American servers. Sometimes it can appear in Indian servers, and so on. Now, why that geographical distribution is important is because if I were to hack that data, in other words, if I were to gain unlawful access to it, who is it that's going to prosecute me? Who is it that's going to punish me? I might be sitting in Hyderabad, access this data that is somewhere across the Atlantic Ocean. So are the Indian authorities the ones who should punish me? Are the authorities of that area where the cloud happens to be at that time the ones who should punish me? So the problem of cloud server hacking is a uniquely contemporary problem based on the unusual way that this property, this so-called property, data, is stored not in a particular jurisdiction or within the authority of a particular police department, or allowing us to treat this case in a way that all criminality and all ideas of property and all ideas of law have always been accustomed to. So this introduces new problems for legal authorities, and it also introduces new problems for philosophers of law on how are we supposed to deal with this issue. As per the Section 69 of the IT Act, and this act has been brought about in an attempt to deal precisely with these kinds of issues like laws related to cloud servers, the Indian government can conduct surveillance. That is, let's say that this data is in the cloud. On the one hand, I've argued that it's therefore unclear whose jurisdiction it's under. If it's unclear whose jurisdiction it's under, it's also unclear whether any authority, whether it be the IB in India, the CBI, the FBI of the United States, or whoever, anyone can simply hack into this and start recording, keeping track of that data. And this is what's known as surveillance. If hacking the data cloud is not as such illegal, and if it's unclear what we do with the hacker, considering the jurisdictional problems, then what is to stop governments from mining data clouds and keeping track of all of us and anyone who has an iPhone or uses Google has a great deal of personal private information uploaded onto the cloud servers. Interestingly, according to the IT Act, Indian authorities are able legally to hack or to access this data. It's possible that this will be challenged in front of the High Court or Supreme Court and ultimately overthrown as constitutional. Certain sections of the IT Act have already been challenged and found to violate fundamental rights of privacy and free expression. The IT Act fails to deter. In other words, we've talked about the nature and the scope of all of the crimes and the need for regulations to properly deter those tendencies toward crime. But in the process of passing the IT Act, it's been diluted so much that most criminologists and legal minds that have attended to the IT Act feel that it has very little dissuasive power after all of the compromises have been made in bringing about the Act as it stands. A lot of these crimes are bailable offenses, which means that the person who commits the crime makes bail and then immediately continues to engage in that crime. Also, there are no provisions within the IT Act on cyber squatting. Cyber squatting is something that, once again, India is notorious for, and the WTO is putting a great deal of pressure on the Indian government to prevent the activity of cyber squatting. What is cyber squatting? Cyber squatting is when a domain name is owned by a specific corporation, let's say eBay, which is a notorious case in India. eBay owns the name. We can just say for now, I don't know if this is the one, www.ebay.com or what have you. And a number of smaller companies start to use variations of this domain in order to redirect traffic meant to go to eBay to their own sites. So let's say that I'm sitting in front of my computer and I decide that I want to use eBay. There are about 142 companies in India that have manipulated the traffic such that the www.ebay directs to their websites instead, and it turns out that I'm engaged not with eBay, which is what I meant to be engaged with, maybe buying things, maybe selling things, but I'm actually engaged with smaller, in many cases, criminal organizations that are trying to access my credit card information or financial information by cyber squatting, by using this domain name to redirect my traffic. Now, these are the kinds of things that can happen. These are the sorts of laws that have been brought about to deal with it, and these are some of the failures of those laws in terms of whether the law itself adequately addresses the crime, and whether, even if it adequately addresses the crime in theory, it's actually applied in practice given administrative problems and corruption. But what about the philosophical implications here? We know that bootlegging is illegal. Does that mean that it's necessarily immoral? Is everything that is illegal immoral? And contrary-wise, is everything that is immoral illegal? Well, clearly that's not the case. So how would philosophers of law and moral theorists take up these issues of IT frauds? On the one hand, we have a great deal of international pressure to curb these frauds. On the other hand, there might be a great deal of internal popular pressure to be more lenient. At this point, you can think about something that has been a controversy in this country for at least 20 years and remains one in countries like Africa. And that is the pressure by certain corporations to force the Indian government to not allow the reverse engineering of kinds of medicines that are the intellectual property of the corporation that created them. So let's take, for example, retroviral medication for AIDS. Now, we all know that this retroviral medication was created by corporations through great investment in R&D, and as a consequence, when the medicine comes out, the price tag is put on it, and that price tag, let's say, is equivalent to $10 US. Now, the company, to exploit the Indian market, may wish to sell it for something less than $10 US. Let's say that it sells it for 400 Indian rupees. 400 Indian rupees might seem like a compromise to the pharmaceutical company that is selling it for less than it sells it for in other markets. But who can really afford 400, 450 rupees for this retroviral medicine? After all, the vast majority of people who suffer from these diseases have hardly that much money to work with, even for a full single day. Analogously, the pressure to curb bootlegging assumes that there's already enough free-flowing information and wealth such that we're opting for the crime rather than opting for access to the data. Is it really the case that file-sharing websites are there because rich people choose to steal files rather than to pay for them? Or is it not the case that the majority of downloads are done by students and others who would otherwise have no access to these kinds of data, books, information, and cinema? So we come back to the Pirate Bay issue. Pirate Bay was created by Swedish citizens who were ordered to shut down the site and who faced criminal charges and were arrested and detained for the criminal activity of sharing files, sharing data that is copyrighted and under intellectual protection. So the United States government and other governments that generally represent the interests of those corporations were very stern and strict and demanded the arrest of these Swedish Pirate Bay founders, as well as the what I had mentioned, injunction against the website remaining live. Now, what happened? Strangely, Swedish population, which has a history of socialist government, similar to India's socialist ideas and socialist pro-poor, pro-common man ideas, the Swedish people protested. They protested in the streets, they protested internationally, and they worked through many different activist networks to get the Pirate Bay founders pardoned and to have the site continue to run, partially through what are considered illegal means and partially through means supported ultimately in the end by the Swedish state itself. And this is an interesting paradigm because, as I had mentioned, the majority of these files that are shared, the data that is shared on the websites that gives people free access to books and films and music, is downloaded by people who could not afford the prices that are demanded for those materials. In conclusion, then, there might be many reasons for the rise in IT fraud in this country, whether it's a tendency toward criminality, which exists in kinds of hacking, asset theft, and data breaches. But one of the main reasons for the large-scale downloading of files and books in India is simply the desire to access information and the need for that information to be shared among all classes of people. So the philosophical question really is whether the legal provisions are ethical legal provisions, whether the behavior that is labeled as fraud and crime are really morally wrong or only legally wrong. This is an open-ended question and it requires a great deal of debate. Thank you.